Hi, James Polk here with Apex Law Service. I'm just going to go over this little list of ethical issues that people sometimes bring up. So I made this blog page article, and also I'm adding this video in to just kind of go over the bullet points of the guideline from the American Bar Association Model Guidelines for the Utilization of Paralegal Services. So I'm just going to go straight down what I have clarified. Guideline 1 is page 5. It's bullet point 3 from Guideline 1. It says that lawyers must instruct paralegals on professional conduct rules and supervise paralegals consistent with the rules. Our paralegals are trained in paralegal training programs and have experience working in law firms. So the way our business model works is that we connect a client who comes to us with an attorney, and the attorney then instructs us on what to do. And when we do the work, we then demonstrate the work we've done to the attorney. The attorney does a brief review and instructs us on any additional work that needs to be done, and that is a form of ratification of the work. It's them functionally supervising us. They do not have to be in the office with us the whole time we're doing work. So that's usually done at a distance and over the phone and through email. So the next guideline is Guideline 2, page 6, bullet point 3 of Guideline 2. Paralegals may not, however, engage in the unauthorized practice of law. Unauthorized practice of law is something that we are trained about in paralegal training, that lawyers obviously they have their licenses to practice law, and no one else but lawyers can practice law, except for sometimes people who are not licensed attorneys can practice law. There are different administrative bodies, administrative hearings where a non-lawyer can practice law. A paralegal in the state of California in a DMV administrative per se hearing can practice law, but technically they still have to be in the employ of an attorney. So we have different paralegals who, if they're available, can do your administrative per se hearing at our paralegal rate. Sometimes the attorney that you hire through us wants to do the administrative per se hearing, not because they want to make more money, but because they just feel it's too intricate to delegate it to a paralegal, even an experienced paralegal experienced with DNV administrative per se hearings. So they do the hearing. But in general, the practice of law has to do with giving advice and representing people. So we do not give legal advice. We only will call if we need documents, and you can call us if you have a question, and it has to be an information type of question. We'll always take your question to the attorney and have the attorney prepare a brief answer for you and then call you. We give them a little heads up. We find that it's more efficient if you call us first, but you are always allowed to call your attorney directly. We are their paralegal as if we're working in their office. They're our supervising attorney, but we're in our own physical office. So, you know, applying the unaided human intellect to somebody's fact pattern and dispensing an advised route through is legal advice. I use the word advise, so that's a little circular, but a suggested route through, and then it's always up to you whether to take that route. So that's what basically legal advice is. Representation is what the attorney provides for you. They represent you in a court of law. So moving on to the next bullet point, Guideline 2, page 6, bullet point 4 of Guideline 2. Generally, paralegals may not appear before adjudicative bodies. The DMV administrative per se hearing is the exception. We simply put together all the documents and do the research, brief writing, all the other types of writing that we have to do for the attorney is what our business does, and we do that at $71.25 rather than $125 to $280 that most law firms charge. So that's the value of using us. We're not attorneys in Apex, but our client attorneys who become our clients who have legal matters attorneys are the attorneys who supervise us. So hopefully that's a little bit of a clarification. let's see, Guideline 3, page 9, bullet point 1 of Guideline 3. I'm going to do bullet point 1, 2, and 3. I'll try to get through these pretty quickly. The lawyer must establish and maintain a relationship with the client to ensure that the client can effectively participate in the representation. What that means is that you have your, as a client, you have your direct line of communication with your attorney. You don't have to go through the intermediary business of Apex Law Service. We market to find clients who need legal representation, and we have you sign a contract with us, and then we present your situation to one or more attorneys, and the attorney who wants to be your attorney or multiple attorneys who wants to be your attorney, we come back to you and we say, hey, here's the attorneys, would you like to talk with each of them? This is what they each basically said. You can talk with them, and when they sign into the contract that you already are offering to them for them to sign into, that is when the attorney-client relationship is established. They themselves are directly establishing that with you. We have these contracts at first, but we are not establishing the attorney-client relationship. They are establishing that directly with you. So you can always, always, always call your attorney directly, but you can always, always, always call us first. We can even help you more efficiently talk with your attorney sometimes. Bullet point number 2, still Guideline 3, page 9. The lawyer must set fees and discuss the basis for the fees directly with the client. If you look at our contract, we require a $500 retainer. You pay 2 retainers with us. You pay one to us, to Apex Law Service, and you pay one to the attorney. So our contract is a contract that the attorney clients are already aware of when they offer to be your attorney after you've offered for them to offer to you to be your attorney. We have in there that you agree to pay, and you write a check to pay $1,000 deposit on a $3,000 retainer. Well, that's not all the fees necessarily, and that's even $3,000 might be more than what the attorney will require. But we ask that our clients write a $1,000 check. You don't have to. You don't have to give it to us to give to the attorney. You can give it to us to give to the attorney because you have work all week and the attorneys are in and out of the office. So we have your contract that you've signed and we have a check that you've signed. We do not intake your check into our bank accounts. If you leave the name of who you're writing the check to blank, you can authorize the attorney over the phone to write their name in there if you choose to accept one of the attorneys who wants to be your attorney. I know it sounds a little convoluted, but these are the fine prints of how what we are doing is ethical and how we save you money. So we don't need you to come into the office multiple times for little things like signing a check. You can leave it there. We give it directly to the attorney. That's not considered setting fees or collecting money for the attorney. It's handing over a check to the attorney. Bullet point 3 from page 9, Guideline 3, paralegals may communicate directly with the client so long as they do not interpret or expand upon the attorney's legal advice. This is one of those functional things. If the ABA said that only an attorney could communicate directly with a client, you'd be getting charged $35 for every it's called 6-minute billing. So that means 1/10 of one attorney hour, and an attorney hour is $350. An associate attorney hour is $300. So you'd be getting charged $30 to $35 just for a 5-minute, for a 1-minute phone conversation. Anything that's up to 6 minutes is 6 minutes billing. That's standard in the industry for attorneys. So you don't want to have to do that just for mundane things like, hey, we need you to send in this document. The attorney has requested these ABC documents, or do you have documentation of having gone to AA or anger management? The attorney would like us to collect that to show to the prosecutor's office for the plea bargain negotiations. That's all stuff we can do. We're not giving you advice there. You calling with a question and about what an attorney meant, we can only barely address that. I mean, we will clarify legal terms, generally understood and accepted legal terms, but we are not going to expand upon the advice. All of us we know where the line is between legal information and legal advice, and we'll tell you, hey, that's a question that we need to direct to the attorney. Are there any other questions you have for them right now? Like, can we go over a few other issues? So when we write the attorney an email, you get the most efficient billing possible for when they call you back, and go over everything. See, Guideline 7, a lawyer should take reasonable measure to prevent conflicts of interest resulting from a paralegal's other employment or interests. This is the least common thing in criminal law. I mean, unless one of our paralegals' family members is one of the alleged victims that is an alleged victim in the case that the prosecuting office has against the defendant. I mean, none of us have worked in the most recent year or years for the prosecutor's office. From time to time, we have paralegal has experience in the prosecutor's office. Usually, it's been a few years, and they've gone into criminal defense, and then we find them when they're switching, when they don't want to work at their law firm, and then they want to do a little bit more of an independent thing. Some of our paralegals are only working on 2 or 3 cases at a time with us, and they're in the office, they're at the law library, they're at the courthouse doing research, doing different things, doing interviews. So they're not always physically in the office, and criminal law industry, criminal defense industry doesn't have those types of conflicts of interest very often. Guideline 8, a lawyer may include a charge for the work performed by a paralegal in setting a charge and or billing for legal services. $71.25 is what you pay Apex Law Service for a paralegal hour. The contract that we have with our our attorney clients, is that they do not charge any money on top of that for the paralegal hours. We do. That's our whole business right there, is saving you money there and doing top-notch paralegal work because we're trained and experienced. So though they can legally, they bind themselves legally by contract not to. That agreement is actually at the top. It says Apex's documents on every page. You can look at all of our business documents right there. Guideline 9, page 20, bullet point 3. Paralegals may never be paid directly or indirectly for referring clients or legal work to the attorney. This is something people bring up. They think we're earning a referral fee for connecting clients to attorneys, and that's not the case at all. We can charge money for what we've spent in marketing, but we do not. What we do in a bargain for exchange is we take as consideration for what we've done to market to find clients, the fact that the attorney limits themselves from upcharging on top of our $71.25 per hour paralegal hour. And that's the only money we earn, is the hours we put in as paralegals as a business. So it's not a marketing fee, and it's not a referral fee. So we're completely outside of that. We do collect our own retainer, and again, the attorney collects their retainer for paralegal hours and attorney hours. Guideline 10, and this is the last one here. A lawyer who employs a paralegal should facilitate the paralegal's participation in appropriate continuing education and pro bono publico activities. Given the nature of our outsourced business, what we do is we always make sure that every paralegal who works for us is up to date on their mandatory continuing legal education hours. And those hours, those seminars, those classes are the very same classes. A paralegal and attorney take the exact same class. Attorneys are required to have 25 hours, paralegals 15 hours. So what we do is we make sure to invite our attorney clients to go to MCLE events with us, and it fosters a better relationship between us and the attorneys. Sometimes they invite us to something that they want to go do as an MCLE, and that's how we deal with making sure that the thing that a lawyer at a law firm is supposed to do for their paralegals and their employee. I make sure that our paralegals are up to date with their MCLEs, and we stay in a social loop with the attorneys. Also, pro bono publical activities. The All in Service Network, www.allinservice.org, is a project that I myself started for kids on juvenile probation to complete their community service hours with religious or non-religious nonprofits. And what I do is I help religious or non-religious groups put together a weekly 3-hour roadside cleanup on an adopted roadway that they adopt from any local roadway adoption agency. And that helps the kids' parents know that they have 3 hours every Saturday or Sunday where they can take the kids after they sign the release of liability form, and they can take the kids and they can leave them for 3 hours and know that they have 3 hours every week to get their community service completed. So that's something that we do, and we encourage our criminal defense attorney clients to be a little bit of a part of that, to help us network, to let people know about it, to let religious and non-religious community leaders know that they can do this project, that will help them put a project together. And a lot of times the attorneys will pick up some pro bono work out of that network. And so that's how we feel that we socially, morally, and ethically are involved in pro bono activities, and we stay in the loop with our MCLEs. So that's the video today. This is going on 17 minutes. Thanks for sticking with me, and I hope you have a great day. This is James Polk with Apex Law Service signing out.